The way I like to talk about a trust when I'm talking with clients is I like to think of this as being a private family entity. So if you think of this thing, and this private family entity can hold stuff, just like I can own things. I can own a home, I can own money, I can own other investments. I can also make it so that my private family entity owns these things as well. This entity is going to be governed by a private family agreement. Private agreements, you sign private agreements all the time, contracts, leases, mortgages, whatever it might be. Private agreements don't need a judge. So when we're working on a trust as part of an estate plan, what we're doing is we want this thing to end up owning the stuff. If we do it the other way, we'll end up going to court oftentimes. That's called probate. What we want to do is bypass that. We want to get our stuff into this private family entity. Anything that ends up in here, the house, investments, whatever it might be, private family agreement, that's our trust agreement, no judge needed. So if someone passes away, if we lose a loved one and they have a revocable trust plan, which is what we tend to focus on when we're talking about trust administration, we're going to be able to make this happen quickly, efficiently, and generally for far less cost than what we would see if we were using a plan that went to court. So trust administration is taking a trust and actually making it work. A trust administrator, sometimes called a trustee, is the person who is the manager of the trust. So similar to if I was creating a will, I'm going to have an executor, sometimes called a personal representative. I'm going to have this person be in charge of my will. Who sells the house, who pays the bills, who makes sure my will does what it's supposed to do. If we have a trust, we have a similar person. This is a trusted role, somebody who's going to take that trust document and do what's in it. Sometimes this process is very straightforward and they don't even need a lawyer. You'll see that now and again. Sometimes they just want to sit down with an attorney for an hour and get an idea of what the next steps are. Sometimes they need quite a bit of help, and our firm certainly is able to provide that help. The way a trust is administered after death is first we need to take a look at whatever that trust document says. If it was created by our firm, we're very familiar with it, but very oftentimes we're looking at documents that were created by other attorneys. So there's going to be a review of that document, and then using that document, there'll be a review of the assets, and that attorney is going to sit down with that trustee, with that trust administrator, and go through what the next steps are going to be. Sometimes it's very easy. Sometimes they need a real estate deed and they got to kick it out to the kids, pay a couple bills, and we're done. Sometimes that trust is creating additional trusts. Sometimes that trust is saying, hey, mine or grandkids, well, now we're going to set up another entity for them to pay for college or whatever it might be. So that attorney is going to walk that trust administrator, that trustee, through that process if that trustee does not want to do it on their own. The most common type of trust that we see is a revocable trust estate plan. That is a special type of trust that is a will replacement. We do it instead of a will. And the reason we do it is we want to avoid this probate process, this court process. So we put together this revocable trust. We use this instead of a will. When someone has passed away, we then have to make that thing work. And in doing so, sell the real estate, pay the bills, what's left. But that's by far and away not the only kind of trust. There's many different kinds of trust there. If you can imagine something happening, there's probably a trust that can make that happen. Other types of trust we see are supplemental or special needs trust. That's a special kind of trust that holds money aside so that a disabled child typically is able to qualify for state benefits without having to spend their entire inheritance on their benefits first. Most of those programs are needs-based. So as soon as somebody gets inheritance, they lose their state benefits. So we can get around that with a supplemental or special needs trust. There are trusts that avoid and mitigate estate tax. There are trusts that assist a spendthrift child or a child who, for whatever reason, is not able to manage their own affairs. So picture someone who's had a substance abuse history or gambling history, somebody who's in a compromised relationship, and we're concerned about that spouse or significant other getting a hold of that money. We can take that money, we can protect it from those folks, but then on the other end of that, eventually it's time to make that thing work. And that trustee sometimes needs help, and we're here for that. My personal history with trust administration is I used to be a trust administrator, a professional trustee. I worked for a large bank in Minneapolis, and then I worked for a smaller bank as well. And what I would do is I would take trusts and do the stuff in them. I didn't create the trust. Someone else had created the trust. I would take that trust document, read through it, and say, okay, here's the things we need to do. I did that personally for about 4,000 trusts. Within our firm, we have 2 attorneys who have been working in estate planning, in trust administration, in probate administration, which we'll talk about on a separate video, for between 5 and 10 years. So the firm generally has been doing this in one form or another for a very long time, or at least the participants within the firm have. They've seen a lot of stuff, a lot of funny things that you might not expect. I wouldn't say they've seen it all, because there's always something that surprises us, but the firm, by and large, has had a lot of trusts pass through its walls. And it's always a really interesting thing to work with a family and to be able to bring some clarity to what can feel like an intense and confusing situation. Our clients hire our firm to represent them in their estate plan for a number of reasons. I think one of them is, honestly, we've had a lot of people say really good things about us. I believe we do very, very good work, and I believe people have made that known to their friends and family. So that's always the biggest compliment we can get, is when someone sends a family member of theirs to work with us as well. Financial professionals trust us, so we get a lot of financial advisors and accountants who send their clients our way to talk about their estate plan, their will, their trust, whatever it might be. More importantly, I think when someone comes to us without being a referral, they just research us online, I think from the minute they call us to the minute they get their kind of overview phone call with one of our staff, to the point where they're actually meeting with their attorney and spending some time talking about the things that are very important to them, their family, their loved ones, the things that they've been working for, I believe there's a level of comfort there. And I believe we really know how to talk to people in a way that isn't lawyerly. I think it's a friendly conversation, and we get a lot done in a very efficient way by working with people where they are. Client communication is one of our values as a firm. The policy within the firm is 8 business hours, but we're much faster than that. We usually try to get back to folks within an hour during weekdays, business hours. But more importantly than that, during the process, we are going to map out with the client when they will hear from their attorney. We are going to map out when there'll be a review call, when they're going to get documents. They're going to know what's going to happen at each step of the process. We are a small law firm. We're right on the corner of Minneapolis and Richfield. We're not downtown. And we have found our advantage to be, we can create a process that is very custom to each individual, rather than having to push that client through the large law firm with all of its many departments. We are able to create something that is very much focused on that family. When we're talking to a new client about trust administration, they're typically going to get an introduction call with an attorney, and then attorney will spend 20 minutes, half an hour, kind of outlining what it is they need to see, what the next steps are. If it's something with which that client or potential client's going to want help doing, we will schedule an initial meeting in our office, do a review of that trust document, make sure it says what we need it to say. Usually if that document was drafted by an attorney, it's going to look good and we're going to be all set. The do-it-yourself documents get a little more funny. If we don't anticipate too many problems, that attorney is going to be able to outline what the next steps are going to be. What assets are out there? Who's supposed to get them? How do we divide them? Who do we talk to next about this? Sometimes that trustee will want to go off on their own and just do it. Sometimes they want us to do that for them, but we would determine that at their discretion at that meeting.